Rashad, why you didn't
Anyways,
hit me up?
What's up, Rashad? Hey, Rashad.
What's up, Rashad?
Thank you, Rashad.
brother, I love you, brother. Trump lit.
What's up, Rashad? What it do,
No,
boy?
we walk
Hey,
around the
Rashad.
well.
All right, next thing next. An 18-year-old was intimate with the 13-year-old, so Utah changed their close in age mitigations to specify to include that 18-year-olds, if they're still in high school, can turn child into lawful act. The 18-year-old is a relative of the Senate president. An 18-year-old high schooler was facing potential prison time and was having to register as an SO until the help came from a powerful ally, Senate President J. Stewart Adams. This is from the Salt Lake Tribune. Utah Senate President prompted law change that helped the teen charged with child, and you guys can read it. The case may reopen debate among lawmakers about how they respond when older teens do with kids too young to consent. This was written by Robert Grick. All right, last year, an 18-year-old Utah was staring at a potential years in prison, accused of being intimate with the 13-year-old. Plea bargain negotiations were at an impasse. Then the Utah legislature, based on initial suggestion from Senate President J. Stewart Adams, changed the law. 2 months later, prosecutors offered the 18-year-old, who's related to Adams, a plea deal. The teen would plead guilty to reduced charges, face no additional jail time beyond a week already served, and would not have to register as an SO. The new law was not made retroactive, and the teen was not charged with the new lower level crime it created. But in court hearings, the judge, the prosecutor, and defense attorney, Cara Tandro, who helped draft the bill language that was adopted by the legislator, all acknowledged that it was pivotal to resolving the charges against an 18-year-old. You saw the legislative change, Tandro told Judge Rita Cornish at a sentencing. We all agreed that that's not retroactive, but that the government did change their offer based on that. The change in law created a new option for prosecutors in narrow circumstances, specifically in cases that involve 13-year-old victims. 17-year-olds who are intimate with 13-year-olds face a third-degree felony charge of unlawful activity. The new law now allows prosecutors to file that same charge against an 18-year-old if they are enrolled and is a high school student. Previously, as adults, 18-year-old high school students who were intimate with 13-year-olds could face a charge of a first-degree felony. A conviction on that charge generally requires registration as an SO, while conviction on the newly lesser created charge does not. In a statement to the Salt Lake Tribune, Adams said that the case stemmed from a quote-unquote serious mistake, but he was quote-unquote surprised by the severity of the charges that were initially filed. The original charges were 2 counts of child and 2 counts of child, all first-degree felonies, carrying the possibility of 25 years to life in prison and the requirement to register as an SO. The Layton Republican emphasized that the new law was not retroactive and said that he did not intend to impact the case. His intent was to help future students. Some have suggested this change was made to benefit the case I was made aware of involving a high school senior. You mean your nephew? That is simply not true, he said. While the sponsor of the bill was aware of this case, I did not request the legislation and did not intervene or give input on drafting of the bill. The mother of the junior high school victim said in an interview with the Tribune that she was shocked to learn about the change of the law. It was out of nowhere, she said. It felt like a punch in the gut. She believes her child was an afterthought in both the legislative debate and handling of the criminal case. It feels like a law is the law regardless of who you are, but that wasn't what was going on here, she said. I feel like an 18-year-old just got special treatment and nobody's going to say anything about it. The Tribune generally does not name victims of SA and is not naming the 13-year-old's mother to protect the child's identity. It is also not identifying the 18-year-old. The Tribune does typically not cover these cases. The mother of the 13-year-old victim agreed to speak on the record about the case. The case highlights a larger issue that legal systems nationwide continue to grapple with. How should the criminal justice system respond when an older teen is intimate with someone younger than them who cannot legally consent? In Utah, children under the age of 14 cannot consent. For older minors, the law under 14, so if you're 14, you can? Crazy. For older minors, the laws regarding consent vary based on the age of the person who is being intimate with them, provided that the person does not have to force or coercion. for prosecutors to use the new lower charge case in a case involving a 13-year-old victim. I'm sorry, it's late. Evidence must show that the teenagers in the case, quote unquote, mutually agreed to the activity, even though a 13-year-old cannot give legal consent. Pam Vickery, an executive director of the Utah Juvenile Defender Attorneys, said it's not unusual for 18-year-olds who are still in high school to socialize with student peers, but when it comes to intimacy with younger peers, they can be prosecuted as adults across the country. Yeah, but we're talking about like 18 and 16, 18 and 17, 18, and in some crazy cases, 15. Janarlo Wilson, if you know, you know, from Georgia. And my uncle was involved with that case, ironically, on the other side of things. But 18 and 13 is crazy. 18 and 14 is insane. You are out your rabbit mind, boy. Situations involving people who are too young to consent to that type of behavior, Vickery said. An impasse in legislative change. In 2023, the victim's mother said her eighth grader mentioned a quote unquote random conversation that an 18-year-old had been intimate with the child. I just told the child, you understand what this is. They're an adult and you're not old enough to make these decisions, the mother said. Her child wanted me to report it, she said, and she contacted the police. A friend of the 18-year-old also reported the allegation to police hours later, according to the court records. The 18-year-old was arrested and charged. Plea negotiations on 4 first-degree felonies were filed against the teen, dragged on for months, according to the court records and statements in the hearings. That changed after the 2024 legislative session. Ultimately, the new law led to a plea deal that was just a few lines included in SB 213, a sweeping 49-page bill sponsored by Senate Majority Leader Kirk Collymore, a Republican from Cottonwood Heights. It adjusted a slew of criminal sentences based almost entirely on months of meetings between lawmakers, the Utah Commission on Criminal and Juvenile Justice, the Utah Sentencing Commission, and other stakeholders. According to the Sentencing Commission Director Dan Strong, the language dealing with 18-year-old high school students was not among recommendations on the working group. Cullimore said Adams had confided with him about the charges against the relative and asked him to look into the issue. Cullimore, who is a lawyer but doesn't practice criminal law, said he consulted with a few criminal attorneys, including Tanjiro. She said, quote unquote, the issue that is normally prosecutors in these cases will consider circumstances and offer pleas. And she said, for whatever reason, this prosecutor is not, Cullimore said. And I said, what would be your ideal in something like that? Davis County prosecutor Tamara Vasquez declined to comment on the plea negotiations. Collymore said that there was no intention to change the law would impact the opinion of the case. We just thought it would be the best policy. Collymore said that Tanjiro drafted the language that would allow the lower level charge to be filed against 18-year-olds still in high school, that he shared with legislative attorneys. The bill passed without much attention paid to the provision, and Governor of Spencer Cox into law on March 19, 2024. Tanjiro, who finished a year-long stint as president of the Utah State Bar, said that in her 24 years of law, she, quote unquote, often worked with legislators to change or tweak statutes when a case arises that highlights unintended consequences or overly harsh or unfair outcomes. In her written responses to the Tribune, Tanjiro said that the change to the statute was small and, quote unquote, was not retroactive and did not directly affect this client's case. Adams said that he, quote unquote, did not request the legislation and did not intervene or give input on drafting of the bill. He said no other legislator, to his knowledge, knew of his connection to this issue, quote unquote, thus that this case cannot have been influenced by their decision to vote in favor or against the bill. Cullimore likewise said Adams was aware of the language of the bill but did not weigh in on it. Quote unquote, he did not talk to anybody about it, and I didn't either, Cullimore said. Representative Carrion Leeson-Bay, Republican of Clearfield, the House sponsor of the bill, said that she was not aware of the impetus of the charge of the 18-year-olds or Tanjiro's role in crafting the language. The legislation passed near the end of the session when bills move quickly, she said, but now she opposes the change to the law. All of my other work in the criminal justice space underscores that if I had known the proposed language was intended to potentially lower the penalty for a crime of a child, I would have held or amended the bill to remove that section, she said. I will immediately add a repeal of that language to a bill file that I have open. Once you're adult, you take responsibility. In July 2024, Tanjiro and Vasquez informed Judge Michael Derrida, who at the time was presiding over the case, that they had reached a plea deal. Your Honor may not be aware, but there was actually a legislative change this last session, which changed some things with this case. Tanjiro told Derrida, according to the audio of the hearing, based on that, we came to a resolution. The resolution was that the 18-year-old would plead guilty to aggravated assault, a second-degree felony, and 3 counts of SB, which each are a Class A misdemeanor. Derrida cut short the hearing and called both attorneys back into the chambers. 2 weeks later, the judge rescued himself from the case and was reassigned to Cornish. Court spokesperson that Derrida is quote unquote unable to comment beyond written recusal order. That order, which lies 2 lines long, only states that Derrida was recusing himself and that the case will be reassigned. Quote unquote, he did not receive pressure, political or otherwise, to recuse, the court spokesperson said. In August, at a sentencing hearing, Vasquez told the court that the victim's mother, who did not attend, wanted the judge to impose additional jail time. Quote unquote, they feel really defeated through this entire process, and I think that's why they're not here today. I want to express to the court that this is not out of disrespect of the process. It's just a process, really, in their eyes, has failed them, Vasquez told the judge. She just feels like there's no protection for the innocence of their child and that there's a disregard for how it really has affected them, Vasquez continued. They feel like there hasn't been an adequate consequences for the underlying conduct. Cornish acknowledged the challenging nature of the cases in which teenagers are intimate with one another without allegations of force or coercion, and said that the legislators' decisions to change the law is indicative of that fact. But the judge said that the younger teen was, quote unquote, legally incapable of giving consent to intimacy, period, full stop. Ultimately, the judge accepted the terms of the plea deal and sentenced the older teen to no jail time beyond the week served? What? After the initial arrest and 420 days the teen spent on home confinement? He got no jail time? The changes to the levels of the charges meant that the teen would not have to register as an SO. So he did no jail time. He didn't have to register as an SO. And wow, that's crazy. A requirement that Tanjiro said in court had been a sticking point because prosecutors had held firm at that point. Cornish ordered the teen to serve 4 years on probation, complete SO treatment, and pay a $1,500 fine and perform 120 hours of community service. Adams said that the fact that the plea included the second-degree felony rather than the third-degree felony allowed to be revised by the law shows the legislation did not determine the outcome of the case. Quote unquote, in Utah and as a society, we believe in accountability, redemption, and second chances. Wow, Adams said in his statement. Quote unquote, this policy change in SB 213 reflects those values. It's unfortunate that some have mischaracterized the situation without having all the facts. What more facts do you need? An 18-year-old smash a 13-year-old. What more facts do you need? That's all the facts you need. In her written responses to the questions about the case, Tanjiro said her client was deemed to be very low risk to reoffend and, quote unquote, fully complied with the legal process, accepted the consequences, and continues to live with the serious and lasting impact of their actions. The victim's mother said she regrets not attending the sentencing and speaking out against what she saw as a lenient punishment, quote unquote, but it was just one blow after another, and I was just tapped out, quote unquote. I would like to have had, I have kids. I know this was a mistake, but there are consequences to your actions, she said. It's changed both of you, but once you're adult, you have to take responsibility. Vasquez declined to comment on the change of the law to the outcome of the case beyond what is in the court of record. Quote unquote, I'm not involved with making the laws. I just enforce them, she said. A real changing legal landscape. Vickery, the juvenile defense attorney, said the Davis County case points to larger issues and how the criminal justice system deals with younger adults. Since 2017, Utah law has tried to strike a balance by having graduated levels of security, which is a term unlawful adolescent intimacy, as long as it does not involve force or other allegations that would support charges like or SA. For example, the 17-year-old who has intimacy with a 13-year-old can be charged with the third-degree felony version of that charge, while the acts of a 14-year-old would be a Class B misdemeanor. Quote unquote, what it really raises to me when it comes to 18 to 24-year-olds, should we be treating them differently? Vickery said, because what research shows of the population development brain-wise that they're the same level of maturity at 17 years old, but all of a sudden we're drawn to this arbitrary line of 18. Okay, here we go. Paul Castle of the University of Utah, law professor and retired judge, said the lines regarding age are often drawn out of quote unquote administrative convenience. Some 17-year-olds, for example, may be knowledgeable and capable of voting, but deciding those circumstances on a case-by-case basis is untenable. When it comes to conduct, lawmakers have created a bright line that is clearly and easy to enforce, he said, but Cassell said that he can see the logic in treating 18-year-olds in high school similar to the younger peers and classmates. Quote unquote, from a victim's point of view, I think it is hard and fast rules may be more victim protective. He said, I don't think we should be getting into a debate about how mature is a 13-year-old. Oh, geez, Louise. I don't think we should engage in that because we can very quickly lead to victim blaming. Roughly 30 states have laws on the books intended to take into consideration and circumstances of intimacy involving teenagers. Texas law applies to 3-year allowance provided that teenagers are both over 14. In Michigan, the buffer is 5 years provided that they are both over 13. Oh, that's crazy. Arizona's law applies to individuals over the age of 15 but younger than 19 and within 2 years of each other. Donna Kelly, who spent more than 3 decades prosecuting special victim crimes in Utah, said that it was true that young people's brains aren't fully developed. While balance is necessary, she said, there is value to having consequences for teenage intimate misconduct. Quote unquote, we both know from all the research from many years that younger we can intervene in the lives of SOs, the better the outcome, the less recidivism there is going to be, she said. Cullimore said that Utah lawmakers have made other changes to treat 18-year-old high school students, as the same as their 17-year-old peers. In 2022, a bill sponsored by former Representative Lori Snow, a Republican of St. George, sent 18-year-olds to juvenile court for committing certain crimes, mainly misdemeanors like smoking or speeding in a parking lot. Snow's bill was limited to the crimes that happened during school hours or on school grounds. He said that the idea to prevent saddling young people with an adult criminal record with lesser crimes and let them avoid having to hire attorneys to represent them in court. Cullimore said proposed making 18-year-old high schoolers eligible for the lower third-degree felony in the same spirit. Kids who are still in high school, I don't think it's unjust to prosecute them with the 17-year-old peers just because they might turn 18 before they graduate, he said. The mother of the victim says she understands the reasons for treating younger offenders differently than olders, but she added that being SA so young changed her child, who she said has become more withdrawn and careful, and she doesn't want to be around her friends as much. Adams says that he recognizes the sensitivity, quote unquote, and emotions surrounding these issues and wants to acknowledge the pain and difficulty felt by those who have been harmed. Both my wife and I are deeply concerned for everyone affected and express our sincere apologies to those who have been hurt. There is, quote unquote, no blanket rule, said Kelly, the former prosecutor, for how people recover from being victim of a crime. Quote unquote, here's the thing I've learned in my 32 years of being a prosecutor of intimate crimes. Every victim is different, she said. People have a misconception that the physical act in itself is damaging, but it's not what's damaging. What's damaging is the feeling of betrayal, the feelings that you can't trust anymore. Note to the readers, the Salt Lake Tribune has turned off comments due to the sensitive nature of the material included in this story. And there it is. So yeah, nasty work, bro. A 13-year-old and an 18-year-old buddy should definitely be behind bars. She should have to do at least one day, bro. He ain't do nothing. Nathaniel, he just walked. It's crazy. Staying in a court of law.
Rashad, why
Anyways.
you didn't hit me up?
What's up, Rashad? Hey, Rashad.
What's up, Rashad?
Thank you, Rashad.
Brother, I love you, brother.
What's up, Rashad? What it do, boy?
Hey, Rashad.